My name is Phil Atkinson. Some of you know me. I'm the Managing Director for A.C.T. And there are various members of the A.C.T. team around today. So if you want any more information about A.C.T., please don't hesitate to ask us. We should all be wearing our ID lanyards, so you should be able to identify us. There have been quite a few of the mock trial events in recent years, and I really do think that what we've done with this trial is quite unique. And without the help of our friends in the legal profession from Magdalen Chambers, it just wouldn't be possible. But we've actually put together a great legal team, and the difference is these guys are practising criminal barristers, a practising judge, and we aim to make the experience for you as realistic as possible. Of course, we can't recreate all the stresses and strains. It is a mock trial after all, but I think you'll see the procedure, the things that happen in as realistic light as possible. So I'd like to say thank you again to our legal team for helping us out with this. As safety professionals, we often talk to people about the penalties involved with breaching health and safety regulations and with accidents happening. But actually, penalties is one thing. You know, sentencing guidelines have changed in the last 12 months. Fines have gone up enormously in the health and safety world. That's one side of it. Actually, what we're going to focus on today is the experience of being in the dock, the experience of being asked questions, of being accused of a criminal offence. And I can tell you, from my experience as a witness in a health and safety trial, it's not a pleasant experience. And I think what you'll get today will prepare you for that experience, should it ever happen to you, and God forbid it does, but it will give you as much preparation as we can give you. So, we aim to achieve that today. The advocates will take time to explain what is going on. They will break the fourth wall and turn around to talk to you and explain what's going on. There will be opportunities for questions at various points throughout the day, and the team will be available at lunchtime, and there'll be a Q&A session at the very end. We are going to use a Slido app, which is up there. So you'll actually be the jury today. You'll get a chance to vote for for guilty or not guilty. Some of you may know Chris Woodford, who's the accused in this case, and you may want to cast your votes beforehand if you know him. But I've casted my vote already. I know where I'm going with this. Yeah. Okay. Thanks for supporting the event. It's a major logistical exercise to get this on. And thanks particularly to the A.C.T. team who've made it possible, who've written the bundles that you should have. All really now is for me to hand over to the legal team, just to introduce them. We have Chris Nash, who's the judge. We have David Campbell, who is the counsel for the prosecution. Gavin Collette is the counsel for defence. And Liz Medland is the clerk to the course. Madam Clerk, I think, is the official title. So I'm going to hand to Liz to continue with proceedings. Thank you.
Good morning, everyone. Before we start the criminal trial properly, we thought we'd show you a little bit of banter that would go on in the robing rooms before a criminal case starts, so that you can see how the advocates interact with each other and the types of things that they would discuss to try and facilitate a settlement to a case and reach an agreement on certain points before the case is called on. So I think I'll hand over to my colleagues, and you can listen to their discussion.
Good morning, everybody. My name is David Campbell. I appear to prosecute this morning. As Liz says, that what we aim to do today is not merely for you to observe what you might think would go on because you've watched Crown Court on TV or Judge John Deed or whatever, or Law and Order, but to try and give you an impression as to what the whole day at court, before the court sits, when the court's not sitting, as well as when the witnesses are being dealt with, and the different speeches from different parties and judicial intervention. Now, if you are a witness in a case, whether it be a civil or a criminal case, you'll be asked to attend court early. And there's a reason for that, because although the judges will be sat there watching television and having an early morning coffee and biscuits at 10:30, the advocates need to make sure that everything is in order before we start a trial. And importantly, we have a duty, and both prosecution and defence teams now have a legal duty, upon pain of costs, to manage the trial efficiently throughout, so that when we're ready to go in at 10:30, we are ready, that all housekeeping and other discussions have already taken place, so that the members of the public who may be jurors and may be witnesses, their time is not wasted. And so Gavin Collett and I, what we'll do is we'll have a brief chat in front of you. Okay, it's realistic. It isn't the same way we would normally speak in a roving room, because we'll try and avoid profanities. We will seek not to ask about what we did in our personal lives the night before, or whether or not you think this new guy who's just started practising is any good. We'll have just a general discussion as we would normally do beforehand. After that, we will also then briefly, in front of you, speak to our witnesses. You will know from the television, in particular with American dramas, and sadly now with a lot of British TV dramas, you will see the lawyers taking a very active role in telling witnesses what to say. That dog doesn't hunt. It does not happen. We're not allowed to do that. And in our experience, we effectively have a pro forma in our own head as to what we say to our witnesses beforehand, to keep within the rules, but also to give them the common courtesy to try and put them at ease before they then go into the crucible of cross-examination, which a Crown Court trial is. So once we've done those two aspects of the preliminaries, then we will start the proceedings properly, with the indictment being put to the defendant. He's the one sat here with the little pointy hat on and the big sign saying he's guilty. And we will be some preliminary arguments in front of the learned judge, which we'll ask him to rule upon, and then we'll get into the witnesses. We hope you have a lovely day. Don't hesitate to ask questions. One of the things which we say to clients when we're defending is that it's better that you ask a question which you think is stupid, because actually 9 times out of 10 it may be, but the information you give to your advocate can often be crucial, because we're only there to articulate on your behalf, and it's important that there is a proper interaction between all parties in any case. So without further ado, Gavin, now we'll begin.
Yeah, well, I'd probably start by, your team's rubbish under Mourinho, isn't he?
Yeah.
Can't score bloody goals, 6th, rubbish. Right, what are we going to do about today?
Well, are you going to plead guilty?
No.
Why not?
Actually, yeah, go on then. No, we're not.
Well, you're not going to offer me anything?
Well, your indictment's overloaded, mate, isn't it?
Well, no, it's
Charge
not.
3 counts where 1 would do.
Well, it's not a matter for you as to how I run my case. You know that each of the counts reflects different aspects of the way in which we say your guy has failed in his duties.
Come on, that's that spiel, that is. It's almost like you've got people watching you. The point is, it's overloaded, isn't it?
Well,
What are you going to do? You're going to drop it to 1?
No,
I
if
can take
you
that to the client?
No, you want to run it in front of the judge.
All right, we'll crack it on. Let's get on with it.
Okay.
We might have taken a bit longer normally, but time's enough.
Have you got any issues which you want to raise in relation to the interviews or any of the witnesses?
No, well, there's a bit on the interview, but let's see how we get on first and see where we get to at that point in time. I'll let you know if there's anything I want to raise with you.
Well, please don't ambush me.
I won't ambush you, but I'll let you know. I'll see how it pans out in the first witness.
Okay, then
I'm going to have a quick word with my client, and we'll talk later.
Okay, you go first.
Then I would then go and have a quick word with my client. Right, prosecutor, he's a bit of a... He's all right, though. He's pretty straight. Judge is a right nightmare. But anyway, could be worse. Bit of a babe is the court clerk. You see what I mean? Anyway, suing court. All right. I might do a bit longer, but you get the idea. I'd go through the evidence, but there's no point me telling you what I'm going to put in about 5 minutes' time in the actual trial. So you go through with the client the positives and negatives of his case. You got a car running? But you'd make sure that they understood both the implications on pleading not guilty, and also credit that would be given if there was a guilty plea, the particular points of the evidence that I think are against us, and to ask him, what do you say, what do the witnesses say? You wouldn't go through what you want him to say, but you, as your client, you would explain what is happening. If he doesn't know what's going on, I failed in my job. He has to understand both what's going to happen, what might happen, and hopefully what will be the outcome. Only then can he make his decisions. Obviously, if he says to me, well, banter rights is guilty, then I would immediately go and see the prosecution and say, we're going to change the plea. He's not going to change his plea because we'll be out of here in about 10 minutes, and that will be a very, very short morning. Good for us, but not really good for you guys. So it's going to be a contested fight. But it would be for me to explain the ramifications and also what it might mean if we lose in sentencing terms. Obviously, it's not I have a crystal ball, but you should be able to explain to your client the parameters that you're facing, the difficulties with the case, and of course the positives. You know, nice court client to look at. Anyway, moving on swiftly. So I'm making a blush, you see. I get a pound every time I do. Right, so that's where I would have a dialogue with him. I can't show you in too much detail because the prosecutor's going to listen, take down all my good notes, and then rubbish my case before I stand up. So I've got to keep a few things up my sleeve for this morning, otherwise it'd be boring. So, but you'd have that discussion. As David says, you'd introduce yourself to your other witnesses, but it would be very much, hello, I'm Mr. Collett, I'm acting on behalf of the company, I'm defending today. So they know who they're looking at when they go into court. Because it's a common misconception that the first person to ask you questions in a courtroom is on your team. It might not be. There might be a witness who you don't particularly want to call, but you've tendered them to the prosecution or vice versa to the defence. So the first barrister to ask them the question might be the other side. So before they start admitting everything to that barrister or agreeing with him or her, it's always a good idea to make sure they know which team is which. So you would introduce yourself. Quite often you would have some discussion first beforehand as to who you're going to be calling and why, and what they assist your case and how they do it. Slightly different rules for prosecution and defence in terms of witness, but obviously we've got to let each other know whom we're calling so there's no surprises on the day. It's none of this, and I now call the murder victim or whatever. It doesn't happen. Sorry. David.
Okay, for the purpose of this, I'll just speak to Mohammed. Okay? Good morning, my name is David Campbell. I'm prosecuting today. Please sit down. Are you nervous?
Yes.
Don't be. Have you had a chance to refresh yourself from the statements which you made in this case?
I have read, and occasionally my mind is going blank, basically, because of the nerves.
Don't worry. Don't worry. Have you got your notebook with you?
No, I haven't.
Why not?
I've left it in the car.
Okay, well, I will speak to the prosecutor and the judge. You need to have that with you when you're in court because you may need to refer to it. Is that okay?
That's fine.
Right, what's going to happen today, Mohammed, is that I can't tell you what to say. Listen to the questions which are being asked and answer them truthfully.
Okay.
Don't worry about why the defence lawyer is asking you questions. That's for me to worry about. Don't second guess anyone. Have you got a wife or a partner?
Yes, sir.
Right. When you're getting questioned by the defence, it's a bit like when you come home after you've done something wrong. Women are better than this than men. What they do is this. They'll ask you a question. You'll answer it. You think you've answered the question, but she says nothing. So then you go and say something else and dig a bigger hole. Women pause. Defence counsel will pause. Don't. Just answer the question. When you've answered the question, that's enough. When you've answered the question, if there's a pause from me, it's because I'm watching the judge write a note of your evidence. That's why I've asked you another question, not because you haven't answered the question to begin with. Do you understand?
I understand.
Okay. What we'll be doing today is you'll be called to give evidence. I'll be asking the questions first. Then the defence barrister will be able to ask questions, and there may be some questions from the judge. Do you want to take the oath when you give evidence, or do you want to affirm?
Affirm.
You want to affirm?
I do.
Is there any questions which you have for me?
No.
Thanks, Thanks, Mohammed.
Thank you.
Okay, so I hope you've got... That's the brief sort of chat you will have with a witness. The one thing the lawyer will not do is discuss your actual evidence. They can discuss around it, they can tell you little tips, they can try and calm you down, but ethically, they cannot discuss your evidence with you. They may well, there comes a time when they will want to discuss your evidence, but they will only do so with the permission of the opponent, and sometimes actually, your opponent lawyer will be there at the same time. So it could well be that there's an issue with your evidence in your statement which is unclear. And back to what I said initially about our duty to manage things so that we don't end up down some rabbit hole with a court taking a court 30 minutes down something which is useless. You know, it could be a typographical error, or they've got a date wrong, and you don't want the defence going on for 15 minutes about was it there, was it then. You can have a conversation, but it must be done transparently so that both sides know what they're doing, so that there can be no thought that anyone from the legal teams are telling anyone what to say. Okay? On the 15th of February of 2016, at Common Lane in Cannock, an event was taking place. And we say that the people who were running that event, MR events, failed in their duty to properly ensure that their health and safety practices were adequate. So much so that as a result of their failings, their criminal failings, an individual suffered a fracture to the hip. This is a business with employees who have responsibilities. This is a business which should have known what it was doing.